or P3 on behalf of Ms. Berry, regarding both matters.
All matters? You say both, but there's 3 files because in 2019 they're separating each one out. And Leslie, so you mean all 3 files?
Yes, I understand both 19, 294 and 95, as well as the 25763.
Okay, thank you. Ms. Berry, your name for the record, please. Okay, thank you. Today's the date scheduled for sentencing on all of these matters. The 25 matter from the city of Wyandotte, it's for disturbing the peace, as that was amended from assault and battery by way of resolution between council. And then on the 2019 cases, those were pled as charged. And council, well, actually, let me double check. Is Ryan Power present?
No, she's not.
What, ma'am? I'm not asking you. Thank you.
Sorry.
And is Bobby Patrick present? Okay.
You have to review the PSIs on both. And it's my understanding that neither were going to be here. There was no request for restitution. And I believe that was document sent to the court from Ms. Powell.
All right, ma'am, how do you know Mr. Patrick or Bobby Patrick? How do you know that individual?
That is my daughter-in-law.
No,
Oh,
listen to Bobby Patrick.
Bobby Patrick from 2019, the stolen property and the trespassing charge. How do you know that individual?
I don't.
All right, and how do you know Ryan Power?
My daughter-in-law.
All right, counsel?
As indicated, I have had an opportunity to review both the reports regarding all 3 cases. And there are no additions, deletions, or corrections to be made. Recommendations on both matters are costs and fines, liquidation. And on the 25 matter, there is part of the recommendation is a GPS file. I want to indicate to the court that Ms. Berry has not had any contact with Mr. Powell's. This has been somewhat, at the time, there's been some contentiousness.
Right, well, also, in my understanding, Ms. Power has a PPO against your client.
She's never been served with you. That's why I was getting to that. I understand that's what it says. However, I asked Ms. Berry that very morning, and she said, no, that thing hasn't been served upon her. Regardless of that, she has absolutely no intention of ever speaking or going with this young woman again. I guess in my review of the discovery of this matter, there was a verbal altercation. It appears that, at least my review is that both parties were mutual in this argument, and then
This guy, that's one.
one thing led to another. That's unfortunate. We are asking as to both matters that the recommendations be adopted. Verity is on limited income. She is on disability. And she is undergoing now lung cancer and other serious medical issues.
So, ma'am, let me ask you this question. You have 9 warrants to the arrest. I'm not sure why you don't handle your matters.
I never received anything in the mail.
Ma'am, hold on. No, listen. I cannot imagine that all of these warrants you did not receive a citation on or anything, that you had zero information that these even were the possibility of existence.
I'm telling the truth. No, I did not receive anything in the mail.
That wasn't my question, ma'am.
Oh,
That wasn't my question. You have 9 warrants. 2 of those are wants. So let's go through that for just one moment, shall we? So your first warrant, let's see, you are Let's see, this is from Third Circuit Court. Possession of narcotics or cocaine less than 25 grams. Okay, that's one. You're gonna tell the court you have no information about that at all.
I don't. I really don't.
Okay. Then we have retail fraud 3. You failed to appear for arraignment pretrial. Okay. So you're telling me you don't know about that one either?
I swear I don't. I really seriously don't.
Out of Garden City, you don't know anything about that.
No.
Okay. Then well, there's a person protection order in here, and I don't know if it's been served, but it's in the system here.
If it is in the system, Your Honor, that's fine, but she has not been served.
Well, I understand that's what she's saying. It does also say on here, personal protection order not served.
Okay.
The court, let's see here.
What was
It's
that?
from 2016, ma'am. 2016. For your shoplifting out of Garden City.
I don't recall, but I don't have any paperwork.
All right. What about the matter that you were on probation for in the 18th District Court for no ops? You were on probation for that and you failed to appear for your probation appointment July 23rd of 2018. You don't know that either.
I have a really bad injury and it affected my memory. I can get paperwork if you need it from my doctor. I don't know. I don't have any paperwork.
And the matter that I mentioned out of the Third Circuit Court, you were on probation for. So I'm not sure how you're unaware of that matter, ma'am, when you were on probation for it. So you either pled guilty or were found guilty. And then somehow you don't know that you have a warrant for your arrest because it's something you did not even know about.
No, because I thought I had taken care of all that business. So I absolutely don't.
Well, there's 2 of those warrants. Then there's another one out of the Dearborn Heights District Court for contempt of court because you failed to pay on your operating while intoxicated matter. You don't know, you're unaware of that one as well?
I don't have any paperwork.
I didn't ask if you had paperwork.
Well, anything in the mail. I've never received anything. And that is another one that I thought I'd take care of because I actually went to county for a little while.
Then on December 24, a warrant was issued out of Allen Park. For driving with a license suspended. You don't know about that one either?
Sure don't. Never got anything in the mail.
Hold on, ma'am. At some point you were pulled over by the police officer, correct?
I was never pulled over. I was already stopped.
Okay. You had contact with the police officer on that date, correct?
Yes.
And then one of 2 things occurred. Either you were arrested and taken into custody, or you were issued a citation.
They took me to the hospital.
Okay. Then they would have issued you a citation.
I never received a citation. I don't know where my mail's going, but
Ma'am, they would have given it to you. They would have handed it to you.
it's probably at home somewhere.
All right. Well, then let's see here. Also, on that same day, it's charging with possession of a knife. So there's a warrant for that as well. And March of 25, another warrant was issued for driving without due care and caution. You must have had an accident in Allen Park, in 24th District Court.
What happened is we were stopped.
No, I'm not asking for factual information. You had an accident.
Yes.
Okay. And then you did not handle your ticket. So there's a warrant for your arrest. You received a ticket, correct?
I have a ticket, yes.
Right. So what did you think you should do with that ticket? Nothing?
I knew I had to call on it.
Okay, well, it's been 9 months. Well, more than that, because the warrant was issued in March. The ticket was issued in 2024. So I'm not sure how long you thought you had to call. All right, and then also you failed to appear for a show cause in the 17th District Court because you had a ticket there for disobey traffic signal and you didn't pay that and you didn't show up for the show cause, so they issued a warrant. So, ma'am, it appears as though you just continue floating through life, not taking care of your matters, as evidenced by the fact that we have 2 from 2019 that we're just now resolving. And your client's going to be taken into custody today to determine whether or not Wayne County Sheriff's coming to pick her up, because it says that she's wanted for that in-state pickup. And those are felony matters, and so she absolutely is going to be taken into custody to determine if Wayne County Sheriff is going to pick her up. That's at a minimum. That's what's happening today. But counsel, you may continue.
Asking that the recommendations be adopted. Court has now gone through a litany of outstanding warrants. As Ms. Berry indicated, 4 years ago, she was in a serious accident. It's affected her memory. I'm not indicating, Your Honor, that is an excuse. However, I think the court should take that into consideration of the circumstances. She's suffering from a number of debilitating injuries. She's on a plethora of prescription medications for all of her illnesses and injuries. She's on a crutch today. She's been on a crutch every time I've seen her.
Well, it's a cane.
A cane.
Yes.
I forgot. I do know the difference, but I misspoke. And I would ask that if the court feels it's necessary to take her into custody regarding the felony warrant, that's obviously the court's prerogative, since there is a pickup, though it's interesting that has been an assistant for quite some time. She's been to this court, and this is the first time we're hearing this, or that I'm hearing.
Well, counsel, I don't necessarily have whether or not on somebody's criminal history. I don't have whether or not they're wanted or not, but at sentencing, I get a different packet of information. So that's why. Had I known that, your client would have handled that on the first date she was here.
I understand that, John. That's why I'm saying I would believe that under today's circumstances, that this is a situation where we could sentence her as to the time served. You're going to put her on I would assume, a GPS tether as part of that recommendation.
Well, I'm not sure if I'm adopting that recommendation, but counsel, I know I just cut you off, but there's a letter in here from Ms. Power, so I'm going to.
That's right. I received it. Yes, I saw it.
I'm going to read this into the record just because it's been received. Okay.
If the court wishes, we have received it, and we would stipulate, Your Honor, that it's in the record.
Okay. All right. Then I won't read it into the record.
You've seen this letter, correct?
No, I'm just saying.
Oh, I sent it to you.
Oh,
Okay.
you know she was intoxicated at the time, right?
Ma'am, stop. Stop trying to put blame on anybody else. Because according to the letter, there's been no contact between her and your son with you. And yet you happen to see her at a restaurant or a bar, and then you began aggressively questioning her regarding her kids, and then you continue on, and that's when you put your hands on her. So do not stand up here now trying to throw mud at the victim in this matter at all. When's the last time you had communication with your son, ma'am?
It's been 9 years.
Okay.
9 years.
If you're at a test right now, ma'am, what's in your system?
Just my medication.
Okay, are you prescribed marijuana?
No, but my doctor knows I smoke it.
That's not my question.
90% of my body.
Stop, that's not my question. So would there be marijuana in your system?
There will be.
Okay, when's the last time you used it?
last night?
Are you currently under the influence of it?
No.
Okay. Do you recall this court's bond conditions that says that you're not to possess or consume any alcohol or drugs that are not prescribed?
Yeah. Yes.
Okay. So you're not prescribed marijuana. Do you have anything from this court that you submitted from your doctor?
No, but I could.
Okay. Since you haven't, you're not allowed to use it right now, ma'am. And the court stated that at your arraignment and then at your last court date. Counsel, I have to tell you, I don't know what the purpose of a GPS tether would be for your client.
Well, there's some, Your Honor, so you indicated that according to your records, that PPO has been obtained. However, she has not been served with it, as you've indicated from that. And your thing is to, well, then basically enforcing a GPS tether. That she's not to be, the GPS tether would force the non-existent or non-served PPO.
Well, okay, but according to Ms. Power in her letter, it's because your client continues to evade service by not having a permanent address by which anybody can serve her, which apparently, according to all the addresses this court has in your client's criminal history, and the fact that your client claims she doesn't get any notification of anything, would it be too far-fetched?
It wouldn't be, except, Your Honor, everything I've sent to Ms. Berry, the court from this address, she received it.
Well, that's good.
Well, I'm just letting you know. So somehow or other, this young woman, I've read the report, has been ongoing problems. And she is making this claim. Ms. Berry has responded to everything I have sent her at the address this court provided me. So where Ms. Powers, is it, states, well, she's evading it. They have an address. She has the address that is on this court record. I don't understand.
I don't know if she has that address. I'm not sure. I don't know what address. I don't know what information is available to individuals with the PIP stuff. But here's the court. Here's what the court is going to take into consideration. Your client has an extremely significant criminal history dating back to 2003.
Correct, Your Honor.
The court also will note that your client seems to have a difficult time with accepting parole in matters. The court will also note that your client, in addition to the extensive criminal history, has 9 warrants and 2 warrants. I understand your client's health is poor. However, given the circumstances, given the allegations, the history, the court on 25673 is going to state that the court does not find that there is reasonable grounds to Department MCL 769.5. The court also finds that the recommendation is not at the level that this court thinks it should be. And the court's going to order 60 days jail for your client on 25673. On 193-295, the court's going to order 30 days jail. Consecutive with the 25673. Consecutive. 193-294 and the trespass, the court's going to order 30 days jail concurrent with 193-295.
Which you're doing basically, Your Honor, 120 days.
90.
Oh.
60 days jail on 25673.
Right.
30 days on the 193-295.
Right.
That's consecutive. The 193-294 is concurrent with the 193-295.
So in other words, she's doing 120 days jail. 60 on the 25 case and 60 on
30. I did concurrent. The 19 cases are concurrent. The 30 days is concurrent with each other. So 960 plus 30 is 90.
Oh, I'm sorry. I thought you said 60 on the one. I apologize.
60 and 25673. Yes.
I thought you also said 60 on the 9-5 case.
No, 30.
Okay, that's where, okay,
If I said 60, I apologize. I wrote 30.
okay.
And I'm going to waive fines and costs
Your Honor?
and warrant fees. All right, you're going out this door today, man.
Any possibility that she could return? Let's get over medications. Yes, wait a bit, medication.
Well, she's got to go this way anyway because we have to confirm if Wayne County's picking her up to begin with.
Okay.
So she can have somebody, it appears she has somebody here with her today. That person can go and retrieve her medications.